Good morning. Our next case is Howard et al. Versus, forgive me, but I will pronounce it MAXISIQ et al. I'm sure you'll correct me during the argument. We will hear from the appellant.
Mr. Chief Justice, Associate Justices, may it please the court. My name is Ben Chesson. Along with our team, Anna Magestro, Amanda Hawkins, and David Allen, I represent the two appellants, 5 Insights LLC and Robert Burleson. Chief Justice, we call it MAXISIQ. You will also hear it called IAMAXIS. It is the same entity. It has a name change during this litigation. And so when you hear from either side, it's talking about the same exact entity. This appeal deals, Your Honors, exclusively with the boundaries of specific personal jurisdiction over non-resident defendants. It centers on whether the Constitution protects 2 non-resident defendants from being added to a dispute that has been pending in North Carolina since 2018. While plaintiff alleges these non-resident defendants participated in a tortious scheme to harm them, it is undisputed that the defendants have never traveled to North Carolina, never conducted activities within North Carolina, never contacted with anyone in North Carolina, or never sent anything into North Carolina as it relates to the alleged tortious scheme, which is the connection for specific jurisdiction. Recognizing these undisputed facts, the trial court nonetheless held it had jurisdiction over these non-resident defendants. The decision was wrong for 2 reasons. First, a non-resident defendant who did not direct the allegedly tortious conduct to or in North Carolina as a forum may not be sued here simply because a plaintiff alleges that the defendant targeted it for harm and the plaintiff alleges that it lives here. On this first error, allegedly targeting a plaintiff for injury does not alone subject a defendant to jurisdiction merely because the plaintiff lives in that forum. Second, on an imputed theory of liability under the DuPont case, that theory does not allow a plaintiff to sue a non-resident defendant in North Carolina who has not assumed the legacy liabilities of the legacy entity or engaged in transfers intended to defraud the creditors. The trial court improperly ignored these fundamental constitutional limitations on jurisdiction that this court and the Supreme Court of the United States have announced in cases like Calder, Walden, and DuPont when it exercised jurisdiction over these 2 defendants. Your Honors, this case involves both theories of direct jurisdiction and imputed jurisdiction. The direct jurisdiction is under the effects test that was outlined by the United States Supreme Court first in a case called Calder, and the imputed jurisdiction theory outlined in a case by this court in DuPont. I'll start with Calder, which relates to both non-resident defendants, Mr. Burleson and 5 Insights, and then move to DuPont, which relates only to 5 Insights. The Calder effects theory of jurisdiction allows a non-resident defendant to be sued in a forum where the forum is both the focal point of the alleged tortious conduct and the harm suffered. The trial court correctly expressed this test and said, quote, the forum can be said to be the focal point of the tortious activity, end quote. That's in paragraph 59 of the trial court's order. But then the trial court ignored that element in its application of the test. Instead, the trial court made 2 essential findings of fact related to both Mr. Burleson and 5 Insights based on different underlying conduct, but the findings of fact are essentially the same. And let me just say, there's a host of findings of fact in the motion to dismiss. It involves issues not related to personal jurisdiction because there are a host of defendants who consented to jurisdiction in this case. But the only findings of facts that are relevant for this court are those that expressly relate to Mr. Burleson and 5 Insights. The first finding of fact is that Mr. Burleson and 5 Insights targeted the plaintiff for harm. The second finding of fact is that the trust is a citizen or resident of North Carolina. On appeal, we don't contest either finding of fact. Of course, don't agree, but don't contest those 2 findings of fact given the standard of review for those. The issue, though, is direct jurisdiction is whether those are sufficient to exercise jurisdiction under Calder. They are not. Those two findings of fact alone are not enough to meet the dual standard under Calder, which requires both that the conduct, that the form that's asserting jurisdiction be the focal point of the tortious conduct and the focal point of the harm. Otherwise, the defendant's connections to the form are merely incidental and as a result insufficient to meet the minimum contacts theory. If you accept the trial court's application of this test and the plaintiff's argument, it reduces Calder into one test, which is where did the plaintiff suffer the harm? That's not enough under the Constitution. There are many decisions from this court and the United States Supreme Court and all over the United States dealing with Calder. It has been written about extensively. I'm going to talk about two. The first is Calder itself, and the second is Walden v. Fiore. In Calder, the court held that California could assert jurisdiction over a non-resident reporter who reached out to contacts in California, wrote a story about a California resident whose professional career was based in California, and then published that story in a magazine that had its largest circulation in California. And there the court said that because the plaintiff felt the harm in California, but also the tortious conduct, the focal point of the tortious conduct was California, California could assert jurisdiction over those non-defendants. About 20 years later, the United States Supreme Court clarified the constraints on Calder jurisdiction in Walden v. Fiore. The court clarified three important points. First, the jurisdiction in Calder was appropriate because, quote, the injury to the plaintiff's reputation in the estimation of the California public connected the defendant's conduct to California, not just to a plaintiff who lived there. It wasn't that enough in that case that Ms. Jones felt the injury in California. It was that the injury itself was to her reputation amongst the California residents. That, for instance, had she lived at the time in Montana, the injury would have still been in California because the article was published there, the folks in California read it, they had less view of Ms. Jones according to her allegations. So it wasn't that she lived there, it was that the harm was there. Second, the court clarified, quote, the plaintiff cannot be the only link between the defendant and the form, end quote. And as a result, defendant's relationship with plaintiff or third party standing alone is insufficient basis for jurisdiction. Third, the court clarified, and I think this is an encapsulation of those first 2 points, quote, the proper question is not where the plaintiff experienced a particular injury or effect, but whether the defendant's conduct connects him to the form in a meaningful way. Applying those principles to the facts in Walden, the court held that jurisdiction in Nevada over a police officer from Georgia was inappropriate, even though in that case it was undisputed that the police officer had intended to cause harm to the plaintiff by taking assets from them in Atlanta-Hartsville Airport, and that the police officer at that time knew the plaintiff resided in Nevada. They knew where the officer knew where the plaintiff would feel the harm and had directed harm towards that plaintiff, yet that was insufficient for jurisdiction in Walden. It's not enough, the court held it's not enough that, quote, simply because he allegedly directed his conduct at plaintiffs who he knew had Nevada connections to exercise jurisdiction in Nevada. The court said it would otherwise impermissibly allow plaintiff's contacts with the defendant and the form to drive jurisdictional analysis.
So why are the tests that you've described, why is that not met here where you have a decedent from North Carolina who owned allegedly 51% of the company, and the harm now to the trust is the decreasing value, the allegation that dividends or payments should have been made to it, and they were bypassed by the others who were basically conspiring against this trust in North Carolina to no longer have what it claimed it was entitled to through the decedent and the trust. Why is that not enough under these two cases?
Your Honor, I think the issue here is that the conduct itself, the defendant's conduct, has no connection to North Carolina.
How does it not have a connection to North Carolina when the trust itself is the one who is injured allegedly by the conduct here.
I think, Your Honor, it's the exact same as the plaintiff in Walden, where the plaintiff in Walden was from Nevada and was on its way to Nevada, and the police officer knew it was going to Nevada, and it experienced the harm in Nevada, yet the police officer's actions had no connection to Nevada. And so here, the trust would feel that exact same harm, whether it was in South Carolina or Tennessee or Montana. The trust would feel the exact same harm, and the defendant's conduct would be the exact same. What was alleged to be done, it would be the exact same. There wasn't, like, Your Honor, a situation where obviously defamatory conduct is its own kind of ball of wax, but there was nothing where they reached out into the state to say bad things about the trust like there was in California, or the other cases we see where a party has entered into a contract with someone in North Carolina and then not performed, and the basis of the contract was to be performed in North Carolina. There has to be something else that connects the conduct to the state. I think what we have here is a pretty rare set of circumstances where you have an assignee of an interest in a company who happens to have incorporated itself or organized itself in North Carolina, who alleges the other members of the company have harmed it through conduct that doesn't touch North Carolina at all. There was no filing with the North Carolina Secretary of State. There was no letter to the trust to say, we've redeemed your interest at no value, and thus we've now sent something into the state of North Carolina. It's much more like Walden, where there's simply no connection to the state of North Carolina other than the trust is here, and the harm it felt in North Carolina, it would feel the exact harm wherever it was.
Using your analogy, though, in Calder in California, what the injury was to the public reputation. I mean, the North Carolina general statutes prohibit or requires the approval of all members of an LLC to convert to a different entity. So isn't there also this larger question of North Carolina as a place to do business and as a place where the legislature has created these protections for members of an LLC? I mean, isn't that kind of analogous to what you're saying the defamation injury was in California? If we then say, well, there's nothing we can do about it from here.
Your Honor, I think the courts have said that violation of a state statute alone isn't enough to connect it to the state. Here, though, I think you have a unique set of circumstances in that you have a handful of defendants who are consented to jurisdiction in the state, the LLC itself, and the members who were members at the time the suit was filed. There is an issue in this case about whether the company was converted before the decedent died. It had been converted since, and by the time of the conduct that we're talking about here, which is 2020, 2021, that entity had been moved to Texas and then Delaware. And so the connection to North Carolina had been gone by that point. So I think that's why you have here a set of defendants involved in this conduct who are subject to jurisdiction, and then you have two who are saying they're not.
But you also have a suit that's been pending since 2018 in North Carolina. To me, when the subject matter of a lawsuit pending is undermined by activities of individuals, that also invokes the North Carolina jurisdiction. Why is that wrong?
Your Honor, I think that's come up in a couple of cases in the federal court where they talk about kind of aiding and abetting the defendants who are subject to jurisdiction violating injunctive orders or things like that, and they said that's not enough. That's more of like a conspiracy theory, which I think the courts have said is insufficient for jurisdiction. I think what we're focused on is on the one hand, are there claims that would create liability for these two defendants? Maybe. Are there contacts with North Carolina that allow those claims to be adjudicated in North Carolina under the constitutional limitations? I think that's a separate question, and that's what we're dealing with here. As it relates to the Calder test, the litigation itself doesn't give rise to the claims. The tortious activity isn't the litigation, the conduct in the litigation. The tortious activity is that you transferred this interest to 5 Insights instead of leaving it with yourselves, and by the way, you paid a management fee that we disagree with. And so I think that's the tortious conduct, and for specific jurisdiction, that's what has to be connected to the form itself.
Am I remembering correctly that Mr. Burleson was the CEO of this North Carolina LLC?
Your Honor, Mr. Burleson was a CEO of North Carolina LLC. I think that, again, what has to be connecting Mr. Burleson, whether it's in his capacity as North Carolina, a CEO of MAXISIQ, or individual defendant outside of that context, is the tortious activity. So he was the CEO for a period of 2016 to, I think, 2020, and he became a member. There's no allegation that in that capacity he was engaged in conduct related to North Carolina that carried out this fraudulent scheme of alleged fraudulent scheme of transferring the interest of 5 Insights and setting up the management fee agreement. And so I think just generally being the CEO of the company isn't enough for jurisdiction. I do also think that would be more of a general jurisdiction argument. Here, you've got specific jurisdiction which must relate the tortious conduct at issue to the jurisdiction. And the focal point of that tortious conduct, whether as CEO or member or director of 5 Insights, has to be in North Carolina. And so I think that's the distinction. I think that to perhaps address Your Honor's first question, Mr. Chief Justice, the court in Walden concluded with that respondents and respondents only lacked access to their funds in Nevada, not because anything independently occurred there, but because Nevada is where respondents chose to be at the time they desired to use the funds seized by plaintiff. And I think that's really what we have here. The trust is saying our interest in this company is worth less because of this activity that occurred by these other defendants. They happened to be in North Carolina when they held that interest, but the conduct that occurred that they say lessened that interest all occurred outside of North Carolina. And there is not a single contact from that tortious conduct or alleged tortious conduct to the state of North Carolina. And I think that's the jurisdictional limitation that Walden imposes on the Calder theory. I think the Fourth Circuit in the Khashoggi case has said that the effects of the act for which a plaintiff seeks relief must create a connection to the form itself, not just a party who happens to live there. And that's what we have here. The connection of the conduct devaluing MAXISIQ, which is a Delaware LLC, to the state of North Carolina, is that the trust happens to be here. I think applying the trial court's order here, the court held that Burleson and 5 Insights targeted the trust. That alone is not enough. And that the trust is a North Carolina resident. That, again, is not enough. The court needed to go a step further and analyze where the focal point of the tortious conduct occurred. And if the court had done that, it would not be in North Carolina. Your Honors, I think that the analogy that I would use related to the Calder test is that if Ms. Jones had lived in Montana at the time instead of California, and the argument there, she tried to sue in Montana, and she said, listen, my professional reputation's in California, it's been ruined, I can't generate money anymore, and I feel that effect in Montana. I think under the Calder analysis, they would say you can't bring the suit there in Montana because the nexus is still California, even though you happen to live in Montana when you want the money or you want the revenue. I think that's exactly what we have here. The nexus is Delaware, MAXISIQ, the interest in that company. The trust just happens to say it holds the interest in North Carolina. Again, if it moved to Tennessee, the conduct would be the same. If it moved to Michigan, the conduct would be the same. Mr. Burleson and 5 Insights would have had to do nothing different to cause harm to the trust in those jurisdictions versus North Carolina. And I think that's the crux of what the Supreme Court clarified in Walden. Your Honors, I'd like to turn to the imputed liability analysis, and I think I will say it's not exactly totally separate because a lot of the allegations that relate to imputed liability theory overlap with the allegations that relate to the Calder effect. I mean, it's this fraud idea, and so it's two theories, some of which comes from the same allegations. I think the fundamental issue with the successor liability theory is there's not a successor. 5 Insights did not acquire MAXISIQ's assets. It acquired the membership interest in MAXISIQ. DuPont recognizes as a theory of liability successor liability theories that were recognized in Bud Tire. The Bud Tire exceptions are by nature an exception to a general rule. The general rule is that a successor company who buys the assets of a legacy company is not also subject to that legacy company's liabilities. No one has asserted that defense in this case because Five Insights isn't a successor. And so without the general rule applying, being a successor liability, claiming no successor liability, the exceptions necessarily can't apply either. And so I think what you have is a round peg and a square hole because we don't have the type of successor transaction that would trigger either a Bud Tire or a DuPont analysis. I think to emphasize that point, you have to start with what the potential liability for the kind of original entity is. And in that case, for MAXISIQ, the plaintiffs seek kind of two main reliefs on their initial claim. One was a declaration that they still own a 51% economic interest in MAXISIQ, and two was for unpaid distributions. And the court can adjudicate that with MAXISIQ. The court, which MAXISIQ has consented to jurisdiction, it's perfectly capable of satisfying both of those claims for relief. Those claims for relief have not, or the assets that would satisfy them, have not moved to Five Insights through a transaction like you had in Bud Tire, where the legacy company sold all of its assets and its goodwill in exchange for cash, or the DuPont transaction, which was, I think, significantly more complicated, but accomplished essentially the same thing. It moved performing assets out of the legacy company to avoid the liabilities that it didn't want attached to those assets. That just simply isn't what happened here. Instead, you have kind of two transactions. One is that Five Insights purchased the membership interest in iMAXIS or MAXISIQ from MAXISIQ's members. That transaction involved no MAXISIQ assets. On the one hand, the members sold their membership interest in MAXISIQ in exchange for receiving a membership interest in Five Insights. And that agreement, the contribution agreement, was in front of the court on the motion to dismiss, and it, on its face, does not, as it wouldn't, because it doesn't involve the assets of the company, make Five Insights responsible for the liabilities. And so the second transaction, Your Honors, is the management service agreement, and there Five Insights agreed to provide management services in exchange for funds. And the fraud alleged is that Five Insights received disguised distributions, that Five Insights received money in addition to what these services should have cost, and those should be classified as distributions, and the trust should get its share. Those aren't the types of legacy liabilities that would be passed to a successor, and so I think, again, you have kind of a square peg and a round hole. If we turn to the four Bud Tire exceptions, I think two are at issue here. The first is that whether Five Insights expressly or implicitly agreed to accept the liabilities of the company. And for that, there's only one conclusory allegation, and it's in paragraph 128 of the second amended complaint, and it says, quote, in conjunction with the Five Insights transfer, Five Insights expressly or implicitly agreed to assume the liabilities of iMAXIS. There's nothing to support that. The court had the agreement that shows on its face that didn't occur. That's record 1014 is the agreement. Contrast that with DuPont, where the trial court looked at the actual agreements between old DuPont and DuPont, Corteva, old DuPont, Chemours, old DuPont, and determined that those agreements actually conveyed the liabilities. Here, you just simply don't have that type of evidence, and so I think the first exception in Bud Tire clearly doesn't apply. The third exception in Bud Tire deals with transfers done for the purpose of defrauding the corporation's creditors. And as applied in DuPont, the transaction must be done to prevent the creditors from holding the original legacy company liable to the full extent and insulate its assets from judgment. There, the trial court made findings of fact that old Pont had a negative net worth, that Chemours was undercapitalized and unable to satisfy the liabilities, that old DuPont had transferred assets for less than consideration, and that new DuPont Corteva knew that Chemours would not be able to satisfy the full extent of the PBOS litigation, including the claims in North Carolina. Bud Tire was the same. There you had a legacy entity sell all of its assets and its business lines in exchange for cash, and the cash wasn't enough to pay its creditors. They got $10,000 and had $12,000 outstanding they owed folks. And so the court said that there, it was clear that they had reduced the amount of the sale price to avoid the creditors. And so as a result, the company that purchased all of Bud Tire's assets was responsible for those liabilities. That's not the case here. First, the trial court did not find, and the plaintiffs have not alleged that MAXISIQ will be unable to pay any likely judgment in this case. Furthermore, MAXISIQ still holds all of its business lines. It's still performing the work for which it receives money, unlike old DuPont and Bud Tire, and that there's nothing that MAXISIQ has a negative net worth or otherwise unable to satisfy the creditors or the potential creditors in this case. And so the third exception to Bud Tire can't exist. I'm going to reserve a little less than I said I was going to, but the remainder of my time to address points of rebuttal.
Thank you, counsel. We'll hear from the appellee.
Good morning, Mr. Chief Justice, Associate Justices. May it please the court, my name is Katie Burchett, and with my co-counsel, together we represent the co-trustees of the Howard Trust. And we are asking your honors today to affirm the trial court's well-reasoned determination that personal jurisdiction exists over 5 Insights and Mr. Burleson based upon competent evidence of their participation in a plan to dissipate and devalue the trust's interest in IOMAXIS or MAXISIQ. And all the while they were participating in this plan, North Carolina was squarely within their sights. Appellant Burleson and 5 Insights are both subject to jurisdiction under the Calder Effects Test, and Appellant 5 Insights is subject to jurisdiction in North Carolina as a successor, as this court has noted in the DuPont case authored by Justice Earls. So the Calder test has 3 components: an intentional tort, that the plaintiff felt the brunt of the harm in the forum, and that the forum is the focal point of the harm. That's 2. 3 is that the defendant expressly aimed the tortious activity at the forum, such that the forum can be said to be the focal point of the activity. The in-forum effects must create a connection to the forum, and we have that here, Your Honors. I will note that Mr. Burleson's participation in this plan actually began in 2018 or 2019. As Defendant Buer testified, Mr. Burleson was in charge of discovery at that time. And we know from the transcripts, from the evidence, that discovery was thwarted or stalled at times in order to permit a corporate restructuring to further remove assets from the trusts and this litigation's reach. And that brings me to the first point, which is that this activity interfered with the North Carolina litigation. A North Carolina litigation was at the center of this activity. It was a driving force of this restructuring. Both Appellant Burleson and 5 Insights expressly and knowingly aimed their tortious activity here. Appellant Burleson again led this discovery, which the trial court actually found on record supplement, pages 173, 174, and this is a separate order appointing the receiver in this case. The court found that the trust position that defendants will continue to assert baseless objections and pursue any and all means to prevent discovery had been borne out. So this is not your typical case. On that, I think Mr. Chesson and I can agree. We have some unusual evidence before the court in this case. We have this finding from the trial court in a separate order, and we have defendants' own statements and their own testimony. There are statements about wanting certain things completed before depositions are undertaken. That is in record pages 770 through 771, the Hirsch affidavit. and in the recorded statement with which this court may be familiar from another appeal found on record page 1829, that we wanted this conversion, the restructuring, done before, quote, done before we go with depositions. There is recorded conversation about using auto-deleting platforms to discuss creative distributions to avoid having to pay the trust its 51% share of those. And as alleged in the complaint on record page 879, there are unsupported claims of national security objections to avoid producing discovery. So an integral part of this plan to siphon assets and to restructure this company to avoid liability is to thwart the litigation, to thwart a North Carolina trust in a North Carolina litigation so that we have time to build and cement this position. And we know this was the purpose because it was part of a joint conversation between co-conspirators to, quote, protect money and distributions from the trust and from the North Carolina litigation. The trial court found on record 1083 through 1084, Burleson has been active in and at times even led efforts that the trust alleges targeted for harm. The trial court found that there was sufficient tortious activity directed to this state. Now, it's in this order. I mean, there are 25 pages in this order of extensive, well-reasoned analysis on this issue. And I would submit to this court that it is in this order. But if this court believes that there is not a precise factual finding to satisfy this test, it may presume one. And that is most recently discussed in Justice Berger, your opinion, I believe, in Button, where no findings are made, proper findings are presumed, and our role on appeal is to review the record for competent evidence to support these presumed findings. If presumed findings of fact are supported by competent evidence, they are conclusive on appeal despite evidence to the contrary. And we have competent evidence of that. It's detailed in our brief, and I've spoken to some of it earlier. And speaking of the plan, that is just what Defendant Burleson and what Defendant 5 Insights did. They formed 5 Insights. They purported to transfer 100% of IOMAXIS's equity to 5 Insights. And let me back up. On April 22nd, 2021, there was conduct in North Carolina. I know Walden speaks to this, whether there was conduct in the state or whether there was travel to the state or whether there were communications to the state. There was conduct in North Carolina. On record, page 1015, section 2.1c of the contribution agreement, right there, all of the named defendants, including the 2 appellants, have signed a document that says this contribution of interest to 5 Insights, it includes 100% of the outstanding equity in IOMAXIS. So on April 22nd, 2021, they reached into North Carolina and scooped out of the trust's pocket an interest it held, a 51% interest it held, and contributed it or purported to contribute it to 5 Insights. So there is conduct in North Carolina. And 5 Insights has since followed through with the plan. 5 Insights was well aware of the trust status in North Carolina at the time of the contribution because it is charged with the knowledge of its corporate officers where those interests are aligned. That's in the Heiss case. And that's exactly what happened. 5 Insights manages, owns, operates IOMAXIS, is funded extensively by IOMAXIS. Between its formation in January of 2024, it received millions from IOMAXIS, and it sold a division of IOMAXIS during the pendency of this litigation. It has received repayments of disguised distributions and presumably distributed those to its members who mirror the ownership of IOMAXIS. And the Muha case and the Walden case are helpful parameters to Calder, but they don't defeat jurisdiction here. In Muha, the defendant did not know that the plaintiff was in North Carolina at the time of his communications to her. And I think it's interesting, Justice Earls, in your opinion, you noted that it could alter the jurisdictional analysis if the defendant had reason to anticipate the plaintiff would seek refuge in North Carolina or if the prior relationship between defendant and plaintiff began in North Carolina. Well, the relationship between this 51% interest and IOMAXIS and all of these other entities, this original relationship began in North Carolina. And the trust has always been in North Carolina. As Chief Justice Newby noted, the trust is the product of a North Carolina resident's estate plan, an estate administered in North Carolina, and the trust is administered in North Carolina. At no point has it been outside of North Carolina. The Walden case did not have these analysis-altering factors. So the police officer, if I'm remembering it correctly, it was uncertain whether the police officer knew the plaintiffs were headed to Nevada at the time that he seized the funds, that they resided there. And in any case, if he learned of it before filing the probable cause affidavit, it did not have a sufficient connection to the forum. That's different here, because truly his only knowledge of the forum, connection to the forum, was through the plaintiff. Here we have repeated and continuing activity directed at a North Carolina trust, directed to avoid responsibility and to thwart a North Carolina litigation. And I think that's material here. And this case is more like the Patch Rubber case, which is not binding on this court, but which is cited in our brief. It's from the Eastern District of North Carolina, 2005, in which a defendant in Virginia received, I believe she was in Virginia, received funds from her husband that he paid to her to avoid a North Carolina judgment. And I think that's what we have here. It's an intentional, knowing avoidance of North Carolina litigation, North Carolina responsibilities. The purpose of taking those funds was to remove from the North Carolina citizens' reach. And in that case, I do believe that the defendant had traveled to North Carolina for the trial. That was noted in the case. But that's not the tortious activity. Traveling to a trial isn't tortious activity. So I don't think our jurisdictional analysis needs to be limited to active commission of the tort. And we, of course, know that Mr. Burleson travels to North Carolina enough to his vacation home and traveled to North Carolina to sign an affidavit in this case. In terms of a framework for determining where does this fall, is this under Calder, is this more like Walden, we have that framework, Your Honors. It's intentional or it's incidental. Is it fortuitous or is it the manifest intent of the parties to have an impact in North Carolina? An interference with a judicial proceeding, interference with rights pursued in a North Carolina court, that's intentionally directed at North Carolina. Again, the defendants, including the two appellants, reached into North Carolina and scooped up 51% from the trust. And that is how they have behaved before that happened and since that has happened. And they did that so that they could restructure and avoid ultimate responsibility in this case. Which brings me to my next point on successor jurisdiction, unless the court would like to ask questions on Calder.
But I would like to talk about the successor jurisdiction, and this is by analogy. Your friend on the other side talks about how we should limit this just to an asset purchase. However, if we look at general securities regulation law, whenever there's a merger or the subsuming of another corporation, the liabilities follow that. I see a similarity here. Do you? As I said, it's only by analogy, and then I would like for him to address that question when he comes back if he's interested.
Absolutely, Your Honor. 5 Insights is the sole owner of MAXISIQ, just as Corteva and New DuPont were the parent and grandparent companies of old DuPont in the DuPont case. Apologies for saying DuPont so many times. And yes, by virtue of that ownership, they have succeeded to the assets and the liabilities of these entities. And to the extent that my colleague would claim a corporate shield should be in place here, I think we've already tested that. You're not entitled to a corporate shield when you've restructured for the purpose of avoiding liability, and that's precisely what DuPont holds. And we have seen again that Five Insights is no meager parent entity. Five Insights manages the day-to-day of IOMAXIS. Five Insights manages IOMAXIS not for a fee, but I would even argue a blank check. Looking at, we haven't seen the full management service agreement, but we've seen the part of it concerning fees. I believe that's at record pages, supplemental record, pages 232 and 233. It's whatever is agreed upon and documented between the parties. And when the receiver asked what that was, it was just, well, whatever the payments are, that's what the documented agreement is. And that's, you know, in and of itself, maybe not a problem. It's a problem when you haven't paid your 51% interest holder for their interest and you are ignoring their interest. And so that goes to the first Bud Tire exception, which is when a party assumes liability, assumes the liability, then it may be held responsible as a successor, and therefore jurisdictional contacts may be imputed to it. The second factor, or second exception, excuse me, under Bud Tire is the transfer is done to defraud creditors, also present in DuPont, also present here. And if I may zoom out for just a moment, Bud Tire focused on an asset sale, and so its articulation of exceptions is necessarily on those terms. But one, I think that this court noted in DuPont that this is not an exhaustive list. And two, if you look at the policy behind this successor liability and imputation of jurisdictional contacts to a successor, it's because the two corporations are really the same entity. It's because whereas here, a company has explicitly assumed certain liabilities or reorganized to avoid the very liability for which it is brought to the court, requiring a merger or corporate continuation to establish successor jurisdiction would serve no additional purpose. And so the policy is the same whether you're talking about acquiring assets or taking over ownership, management, and assets free-flowing to your parent company. But moving on again to the second finding, because the trial court did find that IOMAXIS had assumed liability, that Five Insights had assumed IOMAXIS's liabilities. The Judge Earp was very careful to note that it was not the sole basis for jurisdiction, but on record page 1085, footnote 9, Judge Earp noted the uncontroverted allegation that Five Insights had assumed liabilities. That is enough, and it is supported by competent evidence that I've just discussed with this court. The trial court also found that the restructuring had been undertaken for the purpose of effecting a fraud against creditors. Again, the individual defendants purported to give Five Insights 100% of IOMAXIS when it was not theirs to give. They have purported to run IOMAXIS as if it is 100% owned by the defendants when it is not theirs alone. They have caused IOMAXIS to pay Five Insights millions without support. And there is competent evidence to support the ultimate finding that circumstances warrant imposition of personal jurisdiction based on DuPont and intent to defraud. And so I have some concluding remarks, unless your honors have questions regarding successor jurisdiction. I very much appreciate your consideration of this matter. I will just reiterate that appellants Five Insights and Burleson are subject to this court's and the trial court's personal jurisdiction under the Calder analysis. It is not where you are standing when you expressly aim, but what is in your crosshairs. North Carolina has been in the crosshairs the entire time. Five Insights is also subject to jurisdiction under the Calder analysis and under a theory of successor liability because it is a successor. It is operating. It is calling all of the shots. It has assumed the liabilities, and it was formed for the purpose, or at least a primary purpose, to avoid responsibility. North Carolina has a manifest interest in providing residents with redress for their injuries, and defendants should not be permitted to avoid responsibility simply by moving assets and value out of what they believe is the trusts and this judiciary's reach. Again, thank you for your consideration.
Thank you, counsel. Rebuttal.
Thank you. Justice Manager, I want to make sure I understood your question.
The question I have, and it's really by analogy, I understood your argument to be that you would like for us to limit our analysis of the successor liability to just a situation where there are assets that have been transferred. The analogy in my mind is that if you look in securities regulation, if there's a merger, which would implicate perhaps this equity scooping that your friend on the other side is talking about, that's similar. And in those situations, not for jurisdictional purposes, but for actual where's the liability? The liability then would go to the merged organization because you've taken it up. Can you tell me how my analogy is different or doesn't jive with what you're thinking?
Yes, Your Honor. So I appreciate that and it makes sense. I think what we have here is not a merger because Five Insights obtained the ownership interest in MAXISIQ. So MAXISIQ became a subsidiary, Five Insights, a parent company, not the two of them merged. And so I don't want to cut you off, but
Well, and while you're on that path, just to give you, your friend on the other side made a comment to that without even responding directly to what I was saying, is that this really isn't a parent subsidiary situation, that there really isn't a clear distinction between the two. I suppose perhaps, I don't want to make an argument, but it sounded to me more like a substance over form. So as you continue, if you could explain that.
yes, Your Honor. So I think that it is a parent subsidiary, and I think what they're arguing isn't a merger, it's an alter ego theory, which I think our courts have said are not sufficient to imputate jurisdictional contacts. And so I think it's an alter ego theory that would be what our courts have already said isn't enough. The successor entity is the successor of the other members. So if they had liability, it gets their liability with them, maybe, but it is of the members, not the entity. I think the traditional rule in North Carolina is that merely having a membership interest in the entity, you don't personally have the liabilities of that entity as well. And on that point, Your Honor, I think it's important that the trial court dismissed all of the monetary claims against the individual defendants on the original claims. They said that they were there only as necessary parties to adjudicate the declaratory judgment action. And so as it relates to this action, there was no liability for those individual defendants who Five Insights stepped into the shoes of this transaction. So I don't think you have a merger. I do think you have a parent subsidiary. And I think what their theory is an alter ego theory, which may be successful if they sued them in another jurisdiction for establishing liability. It doesn't establish jurisdictional for imputation of contacts here.
And I do want to make it clear, I understand it wasn't a merger. I was questioning by analogy.
Right. And I think, again, if Five Insights had the assets in the company, then it would be more like a merger. The control of the assets is just like any other sole owner or majority owner. That owner of the business ultimately controls the assets of the business they own, but they don't have the liabilities of the business, and it's generally not considered a merger, even where it's 100% ownership, and even where there may be a piercing the corporate veil theory for recovery after the litigation's over. Ms. Burchett talked a lot about discovery, and I just want to say a couple of things there. One, discovery violations cannot create standalone claims in North Carolina. The court has a lot of authority to deal with discovery violations if there were, and it could do that through the case against the defendants. There has not been a violation of a single court order related to discovery. There's been disputes about whether objections and how those objections were ruled on and the timeliness they were brought. But MAXISIQ has never violated a discovery order in this case. And I would just say for most of the time period Ms. Burchett discussed, our firm didn't represent MAXISIQ in this litigation. We got involved later. And so with that, I'll conclude.
Thank you, counsel.